Thank you, Mr. Speaker. I rise today to speak on Bill S-7, Combating Terrorism Act, which my NDP colleagues and I opposed at second reading and continue to oppose based on the fact that the hearings in the House of Commons Public Safety Committee, or SECU, revealed some serious hidden agendas on the government's part. There are other problems we have with the reenactment of provisions, albeit with some safeguards, from the 2001 Anti-terrorism Act. My colleagues in the third reading debate will address those. But what I'd like to address is how the hearings before the committee confirmed that Bill S-7 creates serious concerns with respect to the rule of law and human rights, notwithstanding the additional safeguards just outlined by the Parliamentary Secretary. During the committee hearings on S-7, my NDP colleagues and I raised several issues related to new offences created by the bill, but our questions were never fully answered by the government. Thus, many of our concerns related to these new attempting to leave the country offences remain, especially, and this is key, how they are linked to the re-enacted counter-terrorism measures from the Anti-terrorism Act of 2001, namely preventive detention, recognizance with conditions, and investigative hearings. For starters, it's clear as day from RCMP and CISA's testimony that the concerns that I voiced in my speech at second reading are very well founded. There's a real potential that attempting to leave the country offences will serve as the trigger, first of all, for investigative hearings that would question friends, families, and community members who know a suspect. Secondly, once evidence arises through that investigative hearing method, that evidence would then be used to engage in up to 72-hour preventative detention and then up to 12 months recognizance with conditions. And indeed, it's important to note, up to 12 months of imprisonment without trial or conviction if one refuses to accept those conditions that are imposed or if one is deemed to have not complied with those conditions. Now, such conditions could and almost certainly would involve confiscating passports so as to create a veiled, backdoor, de facto control order system such as the UK explicitly uses to prohibit leaving the country. The key here is all of this would occur implicitly without it having been debated or structured in a proper way. In this way, the new leaving the country offences need never be actually prosecuted, and that may well be ultimately the government's intention. They are just as likely, if not more likely, to serve as the reference point for disrupting persons' movements by using these reenacted extraordinary procedures of investigative hearings plus the recognizance with conditions provisions in tandem. Now, before this bill came to the House, it was before the Senate. It started in the Senate. In committee there, Minister Nicholson said clearly that investigative hearings could be used to seek and get evidence of intent to leave the country for illicit purposes. As the bill itself states, evidence from investigative hearings cannot be used in criminal proceedings against a person questioned in the hearings. This clearly points to the intention to use investigative hearings to interrogate family, neighbours, friends, and others from a suspect's community, with intended implications for discriminatory profiling, the potential for that discriminatory profiling, and for instilling a feeling of harassment in a community that is the target of counter-terrorism surveillance. Now, the CSIS and the RCMP effectively said, trust us. They say these provisions were not used before they sunsetted, so they won't be used much now. One wonders why the insistence the government has to reenact them. But in any case, don't believe it. Attempting to leave the country is a new offence of wide-ranging impact. And with respect to that offence, or the series of offences that go under that label, the government has every intention of using investigative hearings. Now, Minister Nicholson, in that same testimony before the Senate, also linked recognizance with conditions orders to the new offence. In our committee, Public Security Committee, government witnesses were presented with the scenario whereby evidence from investigative hearings are used not only as a basis for arrest of someone before leaving the country, but also as the basis for securing recognizance with conditions without the need to actually prosecute. Keep in mind, this fancy term, recognizance with conditions, basically means limiting the liberty of citizens without trial or conviction. No witness denied that this trajectory was possible. Now, it must be borne in mind, I want to reiterate this, that any refusal to abide by conditions can lead up to 12 months imprisonment, again, without ever having been tried or convicted. Now, this is obviously a serious chain of state action, and it's for this reason that the NDP not only is against the return of the sunsetted provisions that I've been talking about, but also the reason why we push for a range of additional safeguards to heighten monitoring and accountability in relation to how these provisions will operate in practice. We concentrated at the amendment stage in committee on such safeguards, as it was a given, frankly, that the intrusive provisions would be reenacted by the Conservative majority, or accepted by the Conservative majority in the committee. Such it was that in the committee, we moved something like 18 amendments. Not one was passed, either because the government majority voted them down or because they were ruled beyond the scope of the bill by the chair, and for one other reason, in one case, because the bill had originated in the Senate, which I hope to get to. They were all designed to enhance accountability as the government brings back these sunsetted anti-terrorism law provisions, while adding a new series of leaving the country offences and beefing up, from their point of view, a harbouring terrorist offence. Now, half were ruled out of order, and I will talk about how I argued unsuccessfully that such rulings misunderstood the legislative purposes of the bill and don't take into account a Speaker's ruling recently on when a bill should be deemed to be a money bill. Those are technical matters that we can leave for the moment. But what's important to note, and it was revealed in the Parliamentary Secretary's speech, is that this is a bill with three purposes. And when a number of our amendments were ruled beyond the scope, frankly, the Chair was not taking into account more than one purpose. One purpose is crime repression, terrorism repression. The second is rights protections. We grant to the government that there are some elements in this that are a bit more protective of rights than the measures in 2001, including, for example, the right to counsel before an investigative hearing. We just feel they didn't go nearly far enough. And thirdly, separate from this, is institutional oversight and accountability and transparency mechanisms. These are all interconnected but separate purposes. In our view, every amendment that we propose fits into one or other of these three purposes, and thus none were beyond the scope of the bill. The New Democratic Party believes we must seriously address the issue of terrorism. There can be no doubt of that, but we have to ensure respect for rights and freedoms. That's why we introduced the amendments, to heighten oversight, transparency, and reporting in the bill in order to lessen the negative impacts on civil liberties that this bill is bound to have. These amendments drew on testimony at the committee, and they also, we believe, reflect the values that we believe are important to Canadians. Now let me, Mr. Speaker, describe some of the amendments that were attempted. The First Amendment would have provided for an interagency cooperation protocol between CSIS, RCMP, CBSA, and the Canadian Air Transport Security Agency to be put in place before the leaving the country offences could come into effect. Our rationale was that the exceptional state powers should be carefully circumscribed and accompanied by equally rigorous independent oversight, which a protocol would have to build in. This amendment was deemed inadmissible as being beyond the scope. But the reason we believed the amendment was both necessary and within the scope of the bill was that in the Senate, the director of CSIS drew particular attention to the fact that no protocols exist between these agencies for the kind of cooperation that he said would be needed in order to give effect to the leaving the country offences. And he made it clear that such protocols were necessary. Testimony before us in the committee also indicated this, so we took it seriously by proposing a protocol for collaboration, and that CIRC, the Security Intelligence Review Committee, which is the only relevant existing oversight committee in this field, must endorse it, and only then, once the protocol was in place, would the provisions enter into force. We felt this was a very reasonable provision. Now, because it was ruled out of order and not adopted, we can only hope, Mr. Speaker, that the various relevant agencies will develop a protocol before these new offences enter into force. Now, the Second Amendment related to conditions for people to be charged with an offence related to harbouring terrorists. What the government wants is a provision that says everyone who knowingly harbours or conceals any person whom they know to be a person who is likely to carry out a terrorist activity for the purpose of enabling the person to facilitate or carry out any terrorist activity is guilty of an indictable offence liable to 10 years imprisonment. We wanted to change the words likely to carry out alternative activity to intends to carry out alternative activity. Our view, bolstered by testimony and submissions, for example, from the Canadian Bar Association, is that likelihood is far too lax a standard, especially when you're asking somebody to think through to the state of the mens rea state of another person. The term likely is far too speculative, but the amendment was defeated. The third amendment we proposed was to ensure that testimony gathered from investigative hearings cannot be used against the individual in any extradition and deportation proceedings, and not only criminal proceedings. We heard from the Parliamentary Secretary, Mr. Speaker, that this is implicit. The Supreme Court ruled on this almost 10 years ago and said, in order to be compatible with the Charter, that evidence cannot be used in extradition and deportation proceedings. They acknowledged this in committee, and yet they refused to actually write in the words that says this and makes it clear. We wanted this there simply because we believe that criminal law should be as clear as possible, and that reasons of certainty and caution and respect for the rulings of the Supreme Court necessitated it. At the same time, it was resisted, specifically resisted. And one can only ask whether the government's literally hoping that a newly composed Supreme Court will gradually revisit that jurisprudence, and that the only prohibition will be on using that evidence in criminal proceedings. Otherwise, it's impossible to fathom why they would have resisted including that amendment. We also proposed that the right to counsel, which is written into the S-7, be extended to include a right to state-funded counsel, that is legal aid, if a person is dragged before an investigative hearing. Keep in mind that witnesses are brought before investigative hearings with no necessary and often definitely no suspicion of wrongdoing on their own part. We felt that in that kind of context, it's important to make sure that people are not having to pay the costs of state investigation. We also felt it was especially important to say that the right to counsel is a negative right. Those who can afford it obviously will be able to bring their lawyer and will have much greater protection in the investigative hearing. Anybody who does not have the resources to afford a lawyer, there's nothing in S-7 that would allow them access to a lawyer, despite the fact that elsewhere in the criminal code there is provision for federally appointed, state-funded legal aid. Now, Mr. Speaker, when we got to another amendment, it revealed more information on the government's intent with the bill. We tried amending the provision on recognizance with conditions to make sure it was clear. I want to emphasize this. To make sure it was clear that only persons determined to be potential participants in a terrorist activity could be subject to recognizance with conditions. Our concern was that people who are not themselves suspected of terrorist activity should not be the subject of the restrictions of liberty that are part of the recognizance with conditions regime. We thought this was a friendly amendment. We just thought it was a badly written provision. And we were bowled over in the clause-by-clause process when what we thought was a friendly amendment was resisted. To our shock, the Parliamentary Secretary said the government actually wanted to keep it broad precisely so that recognizance with conditions could be imposed on someone who may not be suspected of any potential criminality themselves. Here's what the Parliamentary Secretary said, and I quote, "The recognizance with conditions in its present form would provide the potential for recognizance with conditions to be imposed to disrupt the nascent phase of a terrorist activity, even where the person who would be subject to the recognizance with conditions is not necessarily the person carrying out the terrorist activity. The proposed amendment would seek to restrict the application of the measure," that's the NDP proposed amendment. She says, "because that is inconsistent with the policy intent underpinning the provision, we are opposed to it," unquote. This government is on record as wishing to permit conditions to be imposed on perfectly innocent people, failure to comply with which can lead to 12 months imprisonment. Is that a regime that we want to have in this country, Mr. Speaker? There's a whole series of amendments we then proposed that dealt with trying to ensure that the reporting procedures that are in S-7 are actually more robust and less general than found in S-7. We wanted detailed information on the statistical use of the provisions, for example. A lot of testimony suggested we needed to have clarity and standards with respect to what the reviews of the operation of the provisions would entail, and we were seeking to assist with that. We also wanted information specifically written in to the review that would talk about exit control and exit information systems. The reason for this is that before the Senate, the Director of CSIS indicated that there are no such comprehensive systems in place in Canada. Yet there was every sign during the committee hearings that the government intends, one way or the other, to move towards more comprehensive exit information, which can lead to exit control systems. It was very clear that not in S-7, but in another piece of legislation, they had created enabling conditions to enable exit information to be accessed earlier than they currently can in the process, so that before planes leave the country, it is known who's on planes, and Canadian officers can go on board and arrest people. Yet this was not put into S-7, but in actually Bill C-45, a budget bill. We were simply taking the cue from the Director of CSIS, who indicated that before the Cabinet, our proposals to strengthen the no-fly list precisely because of the new leaving the country offences. And yet, no information was presented to us on the nature of the debates going on, and we felt it was extremely important to make sure that the review mechanisms down the road ensure that exit information and exit control are taken into account. Mr. Speaker, I believe I'm nearly finished my time, although I've had to be talking over an incredible hubbub and ruckus on the other side of the House. Amendments also sought to ensure that a comprehensive review procedure expressly include the operation of the 4 leaving the country offences.
Order. 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 If members want to carry on conversations with their colleagues, they're free to do so in the lobby, but the member for Toronto-Danforth still has the floor, and it's becoming increasingly difficult for the Speaker to hear him.
Mr. Speaker, I will simply sum up, as I believe I am running towards the end of my time. Once again, the government here exercised its strict policy that we've seen over the last 2 years of no amendments allowed in committee, especially if they come from the opposition. They voted down our suggestion for higher standards, and they were not willing to discuss with us whether the chair's rulings on beyond the scope were correct. Those that were admissible were dismissed completely by the government, who had clear intentions going into the committee not to change a word. There was no interest in strengthening the rule of law or human rights beyond what they had already decided was necessary. It's become clear that the present government has virtually no interest in legislative cooperation in Parliament. In committees, Conservative majorities routinely refuse to consider good faith points from opposition committee members on ways to improve a piece of legislation, even in line with the government's own objectives, let alone to listen to arguments that are serious problems with the bill that need to be fixed. I also want to note one particular slap in the face of the House of Commons. It's worth noting that we prioritized having the Director of CSIS appear before the Public Security Committee. He already appeared before the Senate. He gave testimony that was very important that necessitated detailed follow-up on the part of the House. CSIS knew of the need because it was expressly stated in my second reading speech. CSIS officials came to committee twice, yet on neither occasion did Director Fadden appear. This sequence of events shows major disrespect to the House of Commons when a government official will readily appear before a Senate committee, but decline to appear before a House committee. I would also like to add that there was one ruling that rejected the legal aid funding amendment that said this was improper because the bill had originated in the Senate. It being a Senate bill and the Senate not being able to table money bills, any amendment in the House of Commons having financial consequences was ruled out of order. So the practice of this government of starting legislation in the Senate ties the hand of the House of Commons to engage in the kind of legislative practice that is the right and the privilege of the House of Commons. This is something, Mr. Speaker, that very much needs to be addressed and fixed in the order with which governments introduce bills. Finally, I'd like to say that our Liberal friends on this side of the House voted in favour of this legislation, both at second reading and in committee. I look forward to seeing whether the party that likes to call itself the party of the Charter is ready to rectify this by voting against the unnecessary and fraught measures contained in Bill S-7. Thank you, Mr. Speaker.
Questions and comments. Questions and commentaire. The Honourable Parliamentary Secretary to the Minister of Justice.
Mr. Speaker, I would like to read a quote from the Honourable Member's colleague from Brome-Sequoia. He said, and I quote, "I'm confused about what motivated the government to introduce Bill S-7." And he continued, "Because since 2007, nothing has happened in Canada. The country has not even been subject to a terrorist attack." This was October 17, 2012. What I would ask the Honourable Member is whether he agrees with his colleague from Brome-Sequoia that there is no risk of future terrorist attacks on Canada, and his assumption that the government and Parliament should not pass legislation that will provide the necessary tools that are needed if such an attack were to occur.
The Honourable Member for Toronto-Danforth.
Obviously, there is a concern, a serious concern, with terrorism both globally and in Canada. We had evidence before the committee that I have no reason to disbelieve about a tendency, however large it is, for young members of some communities to actually leave the country in order to be part of terrorist training, etc. There are real issues here. Our point is that the bill went too far, goes too far. We had no evidence of the necessity of the bill beyond that one data item. That was the only thing. Witnesses before the committee from CSIS, the RCMP, and the government detailed as the necessity for reenacting the sunset of provisions. What I've set out is the interconnection between all the provisions and the failure by the government to consider beefing up the protections in a way to meet our concerns. But in terms of the question of the seriousness of terrorism, the need to combat it, I have every reason to believe that we need to be vigilant. Thank you, Mr. Speaker.
The Honourable Member for Winnipeg North.
Mr. Speaker, it is interesting. The member makes reference to the fact that we do need to be vigilant, and I think there is an expectation that Canadians have that the government of the day will do what it can in order to prevent any form of terrorist attacks from occurring, whether it's here in Canada or even abroad. And we do need to recognize that Canada does have a role to play, not only in terms of for the country of Canada, but also one could ultimately argue in terms of a leadership role in itself. Mr. Speaker, even though there are some concerns that we have within the Liberal Party, we do recognize that there is some value in terms of passing the bill. I can sympathize to a certain degree with my New Democratic.
I'm just going to stop the Honourable Member there, just to give the member for Toronto-Danforth a very brief chance to respond, because we do have to move on to member statements. The Honourable Member for Toronto-Danforth. Sorry, I'm going to recognize the Honourable Member for Toronto-Danforth now to let him respond, so we can move on to member statements. The Honourable Member for Toronto-Danforth.
Thank you, Mr. Speaker. I wasn't sure that the member had had time to get to the question. All I will say is that I understand that people are arriving at decisions on S-7 in good faith from different perspectives. I do feel, however, that it's more or less accepted in circles that take charter rights seriously, the rule of law seriously, that the Anti-terrorism Act went too far. So does this bill. Thank you, Mr. Speaker.